my lords. I appear in this matter with Miss Kinsler, Mr. Mackenzie, my learned friend Mr. Beard, my learned friend Mr. Beard, and Mr. Crowther appear for the respondent. I propose to proceed by a few short introductory points, short introductory points, then go to the directives and the regulations. Thirdly, go to Rome 2 and deal with the impact of Rome 2. And fourthly, a few words at the end on any possible reference. I start then with the four overview points, of which I think I'm pretty confident that at least three of them will be common ground between myself and Andy. There's no harmonisation of civil liability and tort arising out of traffic accidents in the EU. Different systems deal with accidents in their own way. Some systems are strict liability based, such as French law for traffic accidents. Others are fault based, like our own. And compensation. Some systems are more generous than others. Sometimes our system in England and Wales is more generous than others. Sometimes other systems, such as the Irish personal injury damages system, it's in the bundle attached to David Holt's witness statement in the core bundle, in the appendix, MS 207, Irish personal injury damages are regularly significantly higher than in England and Wales. Another example is Italian heads of loss can give significantly more damages, especially in fatal cases, where a head of loss is damage arising from the loss of life. And the range of persons, that's rather like in Scotland, I feel, the range of persons who may recover is much broader. So that one might have somebody who goes fishing with somebody every week for 20 years, and then the friend dies, and the fishing friend, at least in Italy it seems, may, at least theoretically, through a close personal relationship, may have a claim. But certainly all members of the family may have claims of varying degrees. The second introductory point is just to note how foreign accidents, i.e. accidents abroad, are litigated today where there is an insurer, i.e. not this case. So if there were an accident in Greece and a Greek driver insured by a Greek insurance company, then the English victim can sue the Greek insurer in the English courts as a matter of interpretation of the Brussels regulation, first established in a case called Odenbright. I think it's in the bundles. Under Rome 2, in that case, i.e. in the insured case, the applicable law to the tort would be Greek law under the general rule in Article 4.1 of the Rome 2 regulation. That says the place of the accident. That law, that is the 4.1 law, defines the scope of the driver's liability for which the insurer is liable to indemnify the victim. And so, in the insurance context, the applicable law to the cause of action remains constant despite the intervention of the insurer. The third point, just go a bit further with this point about the direct right of action with the insurer, just to note that the direct right of action against an insurer is generally provided by statute. It was a little foreign to us when it first arose. We now have it in the 2002 regulations. But across civilian systems, it has been a general principle applicable beyond traffic accidents. I say general, not wholly general, but certainly it's broader than just traffic accidents. That the victim of tortious conduct may well have a direct right of action against an insurer. And the statute providing for the direct right of action would tell you that a claim you have against the driver can be brought against the insurer. Such rights, in a sense, or only in a sense, are essentially of a procedural nature. They're saying that you have a right against the tortfeasor, but you can bring it against the insurer. Such provisions do, of course, create a new right by imposing an obligation, a direct obligation on someone against whom you otherwise have no claim.
But this is general principle, third-party rights against insurers without insolvency.
Indeed.
Yeah. And it applies not just in motor cases, but in any case in continental countries.
Indeed.
Whereas I think under the fourth directive, we're only concerned with such a right of action in the UK in respect to motor insurance.
Yes, indeed, Lord, and that's where the 2002 regulations introduced that.
Yeah.
But the point to note about this is that the fact the statute for providing for direct right of action gives a new right does not necessarily tell you anything about the scope of the right which you have. The normal case, I mean, the existence of a direct right of action, which a victim relies on, is not necessarily governed by the law of the underlying tort. Article 18 of Rome II envisages that there would be a direct right of action, either where the law of the insurance contract so provides, or where the law of the tort so provides. So, while the existence of a direct right is governed by the law of the insurance contract, for example, that's the second example in Article 18, this has no impact on the scope of the cause of action, which remains governed by the law applicable to the tort. So to go back to my example of the Greek accident, a Greek driver and a Greek insurer who is being sued in England under the Odenbright principle, Rome II tells us that the law of the tort is Greek law. Article 18 of Rome II tells us that the existence of a direct right of action depends on the law of the tort or the law of the insurance contract.
So should we just look at that? I thought you said a moment ago it depended on the law governing the insurance.
It is. So Rome II is in is at
7.
7, Lord, yes, on the memory sticks, 398. Mm-hmm. Yes. And your Lordship was correct. Of course, in English law, I think it was through transport that the law which determined whether there was a direct right of action or not was the law applicable to the insurance contract. Here, Article 18 adopts an either-or. So the person having suffered damage may bring his or her claim directly against the insurer of the person liable to provide compensation if the law applicable to the non-contractual obligation or the law applicable to the insurance contract so provides.
I see, right.
So, of course, that's an easy example in a way because the law of the insurance contract and the law of the tort are the same. I mean, if it were, for example, a French driver with a French insurer involved in an accident in Greece with an English victim, then suing in England, Greek law would be the law applicable to the tort. Under 4.2, one can see that just a couple of pages further back. Unless otherwise provided for in this regulation, the law applicable to a non-contractual obligation arising out of a tort dealing shall be the law of the country in which the damage occurs, irrespective of the country in which the event giving rise to the damage occurred, and in respect of the country or countries in which the indirect consequence of that event occurred. So in a traffic accident context, the place of the accident. So Greek law would apply to the tort if the French driver, accident in Greece, English victim. The direct right of action against the French insurer would be available if either Greek law provided for that right or French law provided for that right. Indeed, of course, both laws do provide for it, but just it's important to note, the point I'm just making on this is that it makes no difference at all which law is relied on to get you a direct right of action against the insurer, because the scope of liability for the underlying cause of action is wholly unaffected by the law granting the direct action. I think all this should be common ground.
Yes, but you don't need to rely on Article 18, do you? I thought that under the fourth motor directive, Article 3, there is an express provision for a direct right in any event.
Indeed, my Lord, there is.
Yes.
Yes. Yes. But
they overlap, do they, those provisions?
Well, the Article 3 says that member states shall introduce a direct right of action.
I suppose the answer is Article 3 goes further. Let us suppose that the insurance undertaking covering the tortfeasor, the negligent motorist, the insurance covering the negligent motorist was subject to some law which did not recognise a direct right of action. And let us suppose that the law governing the tort didn't. Nonetheless, Article 3 overrides all that and requires every member state to ensure a direct right of action.
Within the EU law, yes.
Yeah.
I suppose, and I'm looking first of all at the insured case, because of course one would expect a certain parallelism, and indeed the European Court said so, in the uninsured case. that's my fourth point.
Yes.
In our written case, we cite the paragraph 27 from Evans, case in the Court of Justice of the European Union. It's in our written case, MS 76, paragraph 28, where the Court of Justice there said that the intention of the second directive was to entitle victims of injuries caused by an unidentified or an uninsured vehicle, it's MS 76, paragraph 28, to protection equivalent to and as effective as the protection available for victims of insured drivers.
Well, that's clear, isn't it? Also because there are provisions which deal with uncooperative insurers in the same terms as provisions dealing with non-existent insurers.
Indeed, we call them dilatory insurers who don't, who stop communicating, don't communicate, don't respond, etc. And that's Article 6. I mean, I suppose part of the task for this court, what we would say, looking at that passage in Evans, is for the court to stand back from the system created by the directives in conjunction with the Green Card scheme and consider how the victims of insured drivers are protected in order to assess what is likely to be the true import of the scheme for uninsured drivers. One specific point to note at this stage is that it is the law of the tort which applies to your direct action against an insurer, i.e. to the underlying liability, to whether there is liability and what compensation. So it's both liability and the assessment of compensation. So with those introductory remarks, I come to the directives. I preface my remarks on the directives with two short points. First of all, our case is based on the purpose and scheme of the motor insurance directives. That's not merely the scheme of the regulations. That's the way the respondent's case put it at paragraph 5. Our case is that the scheme of the regulations follows the scheme of the directives. So we establish what we can establish from the directives, and that's our case. And then the regulations must be interpreted in accordance with those directives. Before going to the directives, I just recall the position at an international level under the Green Card system. It's expressly referred to in the opening recitals, links 5 and 6, to the fourth directive. And in the bundle at bundle 223, MS 737, we have the current version of the internal regulations. And I'll just
I think you may be driving a bit fast, Mr. Mercer. Just take it a little slowly so we can get the reference.
Well, indeed. So
727.
737. So tab 2, tab 23 in bundle 2.
Yes.
So what document is this?
This is the internal regulations of the Council of Bureau. It deals with, it's the up-to-date version. We have the original versions which introduce the relevant rules.
Council of Bureau being the
Council of Bureaus, this is the Council
liaison.
of the Green Card Bureaus in many different states. So the Green Card system today covers from here to Vladivostok in the east. Russia's, remember, Azerbaijan is the latest signatory to the Green Card system, the Green Card scheme. And this is a system, essentially, whereby it's before 1972, your Lordships may well remember, that when we went abroad, we had to ask for a green card, because in order when we arrived in France, as well as showing your passport, you had to show a green card that your car was insured, to prove that your car was insured. That system persists for essentially non-EEA countries, in large measure. I mean, it's not that the different countries sign up different agreements, but in large measure. So if a Ukrainian vehicle comes into the EU, then it will be asked for a green card at the border. Whereas if a French vehicle obviously comes to the UK or an English vehicle goes to France, it's no longer asked for a green card. We'll see that in a moment. There's a deemed green card system within the EEA states. So these are the internal regulations, up to date, I think, to 2013.
So this is not an EU document?
This is not an EU document, Lord. This is an international document under there was a meeting, it records it in the first recital, In 1949, on page 737, the Working Party on Road Transport, the Inland Transport Committee of the Economic Commission for Europe, the United Nations, sent to governments of member states a recommendation inviting them to ask insurers covering third liability risks in respect to the use of vehicles to conclude agreements for the establishment of uniform and practical provisions to enable motorists to be satisfactorily insured when entering countries where insurance against such risks is compulsory. So essentially, it finds its background in the UN, a request from the UN. It is a body, it exists, its base is in Brussels, in a sense that we have to look at it because the directives have been built against the background of this scheme. I'm only going to draw attention to the most salient paragraphs of it, and essentially the system is that a vehicle carries a green card. That's the basic scheme, is that a vehicle carries a green card, it goes abroad. If the vehicle is involved in an accident abroad, then the local bureau, it was originally in the 1952 agreement, it was referred to as the Handling Bureau. The Handling Bureau investigates the accident, because it's a foreign car with a green card. It investigates the accident, it pays compensation according to its own law, and then it has a right to reimbursement from the paying bureau. The paying bureau is the bureau which issued the green card. And I'll draw your attention, I think it's to 4 provisions. Perhaps if I could just note, what the Lordships are on page 737, recitals 3 and 4a, and so it refers back to the original inter-bureau agreement, text of which was adopted in November 51 by representative insurers and states which at that time responded favourably to the recommendation. And we have, with the principal agreement going back to that time, it's in the supplemental bundle at the first tab, but I don't think we need to look at it. Whereas A, the purpose of the system, commonly known as the green card system, was to facilitate the international circulation of motor vehicles by enabling insurance of third-party liability risks in respect to their use, to fulfil the criteria imposed by the visited country, and in the case of accidents, to guarantee compensation of injured parties in accordance with the national law and regulations of that country. So if a vehicle is travelling abroad, it's involved in an accident, then it's the local law of the accident which determines what compensation is paid, whether there's liability, and then there's reimbursement provision. I just note in passing recital 5, because I'll refer to this in due course. Recital 5 refers to an upgrade to these agreements, which was brought in by the pursuant to the first directive. And so, because I'll be looking at the first directive in a moment, I just show Lordships it at this stage. Whereas some states, in order to facilitate international road traffic, have abolished green card inspection at their frontiers by virtue of agreements signed between their respective bureau, mainly based on vehicle registration. And by the first directive, the EU proposed to the Bureau of Member States the conclusion of such an agreement, then known as the Supplementary Inter-Bureau Agreement, signed on the 16th of October 72. We also have that, it's in tab 2 of the Supplemental Authority. Again, I don't think we need to look at it. It basically, the first directive, as a result of the first directive, the EU member states decided, well, we will no longer require green card at the frontier, and we will just deem all vehicles, whether insured or not, insured or uninsured, to be the holders of a green card. I'm slightly jumping ahead, but I'll just show you all of that because it's there, and we're in this document. And then one notes the purpose, just in passing, in Article 1, the various definitions. And then Article 3 is entitled Handling of Claims. I've used the term the Handling Bureau, but that comes from the 52 agreement. But it's not specifically called that in this agreement. When a bureau is informed of an accident occurring in the territory of the country for which it's competent, involving a vehicle from another country, it shall, without waiting for a formal claim, proceed to investigate the circumstances of the accident. It shall, as soon as possible, give notice of any such accident to the insurer who issued the green card or policy of insurance, or, if appropriate, to the bureau concerned. Any omission to do so shall not, however, be held against it. And so the Handling Bureau, in place of the accident, so in Greece in this case, would notify, in my French vehicle driving around Greece, it would notify the French insurer, and it would notify the French bureau. And then paragraph 4, subparagraph 4 of Article 3, all claims shall be handled by the bureau, that's the handling bureau, with complete autonomy, in conformity with the legal and regulatory provisions applicable in the country of the accident, relating to liability, compensation of injured parties and compulsory insurance, in the best interests of the insurer who issued the green card or policy insurance, or if appropriate, the bureau concerned. And the bureau shall be exclusively competent for all matters concerning the interpretation of the law applicable in the country of the accident and the settlement of the claim. And there are provisions for some consultation. So that's the basic obligations of the handling bureau. That's the place of the accident. So in our case, it would be Greece. And then in Article 5, Articles 5 and 6 deal with the reimbursement. So Article 5.1, when a bureau has settled all claims arising out of the same accident, it shall send, within a maximum period of 1 year from the date of the last payment, by fax or email, to the member of the bureau which issued the green card or policy insurance, or if appropriate to the bureau concerned, a demand for reimbursement specifying. And the demand for reimbursement shall specify 1.1, the sums paid as compensation and various costs. So when it says the sums paid as compensation, that's the sums which have been computed in conformity with legal and regulatory provisions of the country of the accident. And then Article 6.1, each bureau shall guarantee the reimbursement by its members, that's the insurers, the insurer members of each bureau, of any amount demanded in accordance with the provisions of Article 5 by the bureau of the country of the accident or by the agents appointed for that purpose. So this is the essential scope of the original green card scheme going back to the early 1950s. And we can, if necessary, we can see that in supplemental bundle. So that you carry a green card, you drive to another country, you're involved in an accident, the handling bureau investigates the accident, pays out under its own law, seeks reimbursement back from the paying bureau, if you like, the home bureau of the vehicle which is travelling, which has travelled. This is what one might call the visiting vehicle scenario. It's relevant, though, because it forms the essential backdrop, and it was modified by the first directive. It's relevant to the issues which are before the court.
What happens if the measure of damages was different in different countries, and you had a claim in country B, not the country where the accident occurred, and you could proceed in country B, not the one where the country's incurred? Does this scheme apply to that at all?
Not at this stage, Lord. The presumption
there was a time in which some countries, indeed the UK, had a position before Rome II, didn't it, whereby the measure of damages were assessed in accordance with English law, though the other aspects of the matter were done by the lex loci delicti.
Absolutely, Harding and Whelan's, Lord, indeed.
Yeah.
Yes.
So this scheme has nothing to do with that kind of situation, does it, or does it?
Well, we say not.
Yeah, okay.
Because it's clear right from the very beginning, and that the same scheme, if one likes, that you handle the accident in accordance with the law of the place of the accident, the same scheme applies when you introduce the concept of guarantee funds for those vehicles which are those vehicles from within your state which happen to be uninsured. I mean, it's right also, my learned junior reminds me that, of course, the difficulty in the case your lordship posits is that you generally couldn't found jurisdiction in England in respect of a foreign traffic accident. It's the Odenbright case which brings the foreign insurer into the English court.
If you managed to, you wouldn't have a right against the compensating body in the country of the accident. You might have a right to go against any insurer you could find in the country of origin of the driver. Indeed. And under that scenario that my lord's postulated, that insurer might have to lump it if he had to pay under the old English law.
Yes, indeed.
Higher damages than would be recoverable in the country of the accident.
I now go to the directives, Now, the accident was in this case, occurred on the 17th of May 2011. And therefore, the codified directive, if one likes, it's in Bundle 1. The codified directive, in fact, applies. It's MS 348. The codified directive is at tab 5 in Bundle 1. But I won't be referring to tab 5 at this stage. I'll try and give your lordships the cross-references I go through. And the reason is this. The reason is that we rely heavily on the scheme of these directives and the way in which they build up the protection. And therefore, it's important in our submission that we look at the first, second, and fourth directives in that order to see what innovations each of those directives introduced. Because the fourth directive, as we know, refers back to the second directive, which refers back to the first. So the first directive is in tab 1. And page 329. So in Article 1, which is the definitions, which is worth noting, the injured party means any person entitled to compensation in respect of any loss or injury caused by vehicles. That's important because that comes back in the fourth directive, Article 1.1. And we say that's a really important part of the way in which these directives work. So if you're an injured party, you have an entitlement to compensation. We all remember, of course, Lord Hoffman's words. I mean, it's not in the context of a new directive, but you don't have a right to compensation in the abstract. It's in Harding and Whelan's, in fact. You don't have a right to compensation in the abstract. It's a right to compensation for something in accordance with the law. It doesn't exist in the ether. The second definition I draw your attention to, National Insurers Bureau, means a professional organisation constituted in accordance with the recommendation number 5, adopted on 25th of January 1949 by the Road Transport Subcommittee of the Inland Transport Committee of the United Nations. So that's the express reference to the Green Card scheme. The territory in which the vehicle is normally based means the territory in which the vehicle is registered. That's the primary rule. I think that's all we need to note at this stage. And then in 5, Green Card means an international certificate of insurance issued on behalf of a national bureau in accordance with that recommendation. That's why I went first of all to the Green Card scheme. And then the critical obligation introduced by this directive is Article 3.1. Well, in fact, Articles 3, 1 and 2. Each member state shall, subject to Article 4, take all appropriate measures to ensure that civil liability in respect of the use of vehicles normally based in its territory, it's basically with its registration plate, is covered by insurance. The extent of liability covered and terms and conditions of cover should be determined on the basis of these measures. And then each member state shall take all appropriate measures to ensure the contract insurance also covers, according to law enforced in other member states, any loss or injury which is caused in the territory of those states. So the contract insurance must not only cover the level of liability in your own state, but must also cover the loss or injury caused in the territory of other states, according to the law enforced there. And then the second point, the second article I'd like to go to, a substantive article, is Article 2.2, because this is what led to a change in the Green Card scheme. As regards vehicles normally based in the territory of a member state, the provisions of this directive, with the exception of Articles 3 and 4, shall take effect after an agreement has been concluded between the 6 National Insurers Bureau, under the terms of which each national bureau guarantees the settlement in accordance with the provisions of its own national law on compulsory insurance of claims in respect of accidents occurring in its territory by vehicles normally based in the territory of another member state, whether or not such vehicles are insured. So if we go back to my phraseology taken from the 53 agreement, the handling bureau, this is the handling bureau, the place of the accident, guarantees, in accordance with the provisions of its own national law on compulsory insurance, claims for accidents on its territory caused by vehicles normally based in the territory of another member state. This is about visiting vehicles. i.e. a classic green card case. The thing to note here is that whether or not such vehicles are insured. Now, in fact, the mechanism which the member states used to achieve, which the bureaus used to achieve the purpose here was to make a supplementary agreement, it's tab 2 of the supplemental authorities, which deemed all EU, and indeed I think EEA vehicles, to be the bearers of a green card. And that deeming provision meant that every vehicle which crosses a frontier in Europe is assumed to be the bearer of a green card, and if it's involved in an accident, then the green card scheme takes over, whereby the bureau local to the accident, the handling bureau, investigates, pays out under its own law, and seeks reimbursement from either the insurer of the home state of the vehicle, or if no insurer, the paying bureau. So, just 4 things to note. It's the bureau local to the accident who guarantees to settle the claim. Secondly, it's in accordance with the provisions of its own national law on compulsory insurance. Thirdly, this is a system for visiting vehicles, for visiting vehicles. And fourthly, all vehicles are covered, whether insured or not. So whilst this is illustrative of a wider point, which is that the green card scheme and the EU directives are complementary parts of a single system, it's important to note that the first directive did extend to visiting uninsured vehicles. I come therefore to the second directive, which is at 331, page 331, it's in tab 2. Article 1 is giving quite a big job to do. We're mainly concerned with Article 1.4, but we note in passing on page 332 that, first of all, Article 1.1 and Article 1.2. So Article 1.1, the insurance referred to in Article 3.1 of the first directive, so that's what we've just looked at, i.e. the idea, the obligation on member states to ensure that every vehicle normally based in its territory was covered by insurance. So the insurance shall compulsorily cover both damage to property and personal injuries. That's because at the time some laws excluded one of those. 1.2 introduces some minimum guarantees in terms of the level of cover. I mean, these levels of cover set out in the first directive have been significantly increased, but it sets down minima. I think the current minima is €1 million per victim or 5 million euros per claim. But it sets down minima. So, and then I come to 1.4. Each member state shall set up or authorise a body with the task of providing compensation at least up to the limits of the insurance obligation. The insurance obligation is that insurance obligation from 3.1, the first directive, and referred to in Article 1.1 of this directive. So up to the limits of the insurance obligation for damage to property or personal injuries caused by an unidentified vehicle or a vehicle for which the insurance obligation provided for in paragraph 1 has not been satisfied. So the insurance obligation goes back to 1.1, which goes back to 3.1 of the first directive. That's the essential provision. And then, this provision, there are various options then given to member states. So they've got to set up this body or authorise it. They can use the same body, which is already the Bureau, as the UK did, nominating the MIB, which was already the Green Card Bureau. Or they can set up a separate body. Apparently Spain has a separate Bureau, Guarantee Fund and Compensation Body, I think. So this provision shall be without prejudice the right of member states to regard compensation by that body, that's I'm calling it the Guarantee Fund, and I take that from the fourth directive, that the label, but that's what I'm calling, just for shorthand, the Article 1.4 body is the Guarantee Fund. So this provision shall be without prejudice the right of member states to regard compensation by that body as subsidiary or non-subsidiary. So that refers to the position which prevails, for example, in France, where by case law developments, the Fonds de Garantie, which is the Article 1.4 body, is only liable where no insurer is liable. And whether an insurer is liable is very broadly interpreted, because an insurer is liable if any car and if any vehicle is implicated in the accident, impliqué in the accident, which basically, I mean, some debate, there was a case about this, but basically, if it's on the scene at the relevant time, there's no necessarily causative link required. And so the way the French interpret the rules in relation to the Fonds de Garantie is that, well, if any insurer is on the scene, any vehicle's on the scene which is insured, then that insurer picks up the tab for the accident, whether or not that vehicle was responsible. So the Fonds de Garantie's liability is, if one likes, really very much at the end of the line, only if all else fails. And then, second subparagraph 1.4, the victim may in any case apply directly to the body, which on the basis of information provided at its request, shall be obliged to give them a reasoned reply regarding the payment of any compensation. So victims may apply directly to the Guarantee Fund. And then we get more options, as I'm calling them, in the next three subparagraphs. So these are options for member states when they set up or authorise this Guarantee Fund. They can not only say this liability is subsidiary, but they can also say that member states may exclude the payment of compensation by that body in respect of persons who voluntarily enter the vehicle which caused the damage or injury when the body can prove that they knew it was uninsured. Member states, when they set up these bodies, could have also, in the next subparagraph, limited or excluded the payment of compensation by that body in the event of damage to property by an unidentified vehicle. And they could also authorise, in the case of damage to property caused by an uninsured vehicle, an excess of not more than 500 EQs for that time, for which the victim may be responsible. And then at the bottom, furthermore, each member state shall apply its laws, regulations, and administrative provisions to the payment of compensation by this body. So guarantee funds, the member states, when they set them up, they're required to say guarantee funds shall apply the laws, regulations, and administrative provisions of the member state setting up that guarantee fund, without prejudice to any other practice more favourable to the victim. So that's the essential part. I think I've made the points. I mean, so set up or authorised could be the same body as the Bureau. Each and every member state had to set up a guarantee fund, meaning that the entire territory of the EU would be covered by such guarantee funds. Each fund...
But this, does this mean then that the UK Motor Insurers Bureau, which is obliged to cover vehicles which haven't taken out insurance in respect of accidents in Greece, under the last paragraph, applies its own laws, regulations and administrative provisions to the payment of compensation. Is that?
Lord, it doesn't.
It doesn't, no.
It doesn't, because the MIB as compensation body, and we'll come on to this in the fourth directive, its liabilities by reference to the situation of the guarantee fund, we say in the state of the accident.
So, but what we're just looking at the second directive at the moment.
We are.
The second directive is saying, recognising that everyone should have insurance not only in respect of accidents in the country where their vehicle is based, but also in respect of accidents in France, Greece, Germany, etc. If that obligation isn't satisfied, then the Motor Insurers Bureau of the UK has to meet, pay compensation, and this last paragraph might suggest it had to pay it in accordance with UK law. Is that right?
With respect, not my lord, because visiting vehicles have already been dealt with by the Green Card scheme. So if an English vehicle goes across to France, Germany, etc., then that remains within the Green Card scheme. And so if it's involved in an accident in France, the French bureau would handle that and then seek reimbursement from the MIB.
Yes, I see.
Qua bureau.
So what situations?
This is concerned with domestic accidents where the driver is uninsured and because it's by reference to the...
So it's not dealing with green card situations?
It's not dealing with green card situations. It's supplemental to green card
It's in very broad terms, though, isn't it?
But Lord, it's in broad terms on the setting up of that guarantee fund. Guarantee fund responsible for, the vehicles which that member state has failed to insure, pursuant to 3.1 of the first directive, has failed to insure, are insured.
So you say at this stage the situation that's now covered by the fourth directive was covered by the green card scheme. And this wasn't addressing. This wasn't addressing. The second directive wasn't addressing the liability of the MIB in respect of a foreign accident.
That's right, Lord.
Yes, I see.
I don't know if it might help. I tried to do a little diagram. And diagrams sometimes appeal to some and not to others. And Alistair, have you got a copy of the diagrams? Some copies for the war cards as well. Yes, of course, yeah.
Thank you.
So what I was explaining was the green card scheme is the top left and centre. So I've used the terms of the 53 agreement. If there's member state of the accident is the centre column, the handling bureau investigates the accident and settles with the victim, assuming the victim is approaching the handling bureau in the member state of the accident, and is then reimbursed by the paying bureau. And the handling bureau guarantees settlement in accordance with its own national law of compulsory insurance. That's Article 2.2 of the first directive. So the green card scheme is at the top there, paying bureau, handling bureau. So the green card scheme continues to deal with visiting vehicles. So a vehicle outside the state where it's normally kept. Now, for accidents in a member state, Article 1.4 of the second directive requires member states to set up a guarantee fund. That's the bottom of the centre column. And that guarantee fund pays under its own laws, and liability may be restricted, limited by member state options set out in Article 1.4 of the second directive. In terms of the scope of the guarantee fund liability, member states were required by Article 3.1 of the first directive to take appropriate measures to ensure that civil liability in respect of vehicles normally based in their territory were covered by insurance. That is referred to in Article 1.1 second directive. And then Article 1.4 refers to at least up to the limits of the insurance obligation. The insurance obligation is that obligation on member states to ensure that civil liability in respect of vehicles normally based in its territory are covered by insurance. And so, for unlikes, the guarantee fund is dealing with the case where member states were required to ensure vehicles were insured and have not managed it. So the guarantee fund doesn't interfere with the green card scheme, it supplements it by dealing with uninsured vehicles from the state of the accident, which are involved in an accident. It's to ensure that the victims are covered by an insurance obligation. The insurance obligation under the second directive, it can be subject to, within certain parameters set out in Article 1.4. It may be somewhat limited, as the example I gave your Lordships of France, and various limitations on the cover in respect of damage to property. So these systems, the green card system at the top and the guarantee fund system at the bottom, complement each other, but seek to ensure that victims, come what may, will have compensation, will actually receive their compensation, because there is a party there to cover the compensation, either an insurer or a bureau, or from the second directive, the guarantee fund. And so the guarantee fund, which is formed under the second directive, is not responsible for visiting vehicles, visiting uninsured vehicles, because visiting uninsured vehicles are already dealt with pursuant to Article 2.2 of the first directive under the green card scheme at the top, the paying bureau, handling bureau system. So I then come on to the fourth directive. I start in the recitals. It's on page 338, in tab 4, Lords of the bundle. So the first recital simply notes that differences exist relating to the insurance between member states, relating to insurance against civil liability. 5 and 6 refer to the green card system. So the green card bureau system ensures the ready settlement of claims, or might insert there, against visiting vehicles, because that's what it applies to, in the injured party's own country, even where the other party, that's the driver, comes from a different European country. But the green card bureau system does not solve all the problems of an injured party having to claim in another country. That's then the visiting victim scenario, which the fourth directive goes on to deal with. And the all is somewhat odd, but anyway, there we are. It doesn't, because it's debatable whether the green card bureau system really solves any of those problems. But the green card bureau system does not solve all the problems of the injured party having to claim in another country against a party resident there, an insurance undertaking authorised there, foreign legal system, foreign language, unfamiliar settlement procedures, often unreasonably delayed settlement. The element of dépaysement. So you've been to France on holiday, you were unfortunately involved in an accident, you come home before the fourth directive, you had to approach the Fonds de Garantie. You had to get somebody in France to approach the Fonds de Garantie for you. You had to possibly appoint lawyers, and so on and so forth. And the result was, as the European Parliament noted in a resolution, that many people went without compensation unless it was really serious, because the practical hurdles were so significant. And really that's quite important in the context of this directive, because we have to look, obviously, at, with our submission, the court must look, at what was the scope of this directive, what was it trying to do, what was its task? And its task, we say, was to deal with those practical hurdles. And then in recital 8, it's in fact appropriate to supplement the arrangements established by the first, second and third directives in order to guarantee injured parties suffering loss or injury as a result of a motor vehicle accident comparable treatment, irrespective of where in the community where accidents occur, for accidents falling within the scope of this directive occurring in a state other than that of the state injured party's residence. There are gaps with regard to the settlement of injured parties' claims.
Some significance may attach to the words comparable treatment. Right?
Well, indeed, Lord. It's not precisely the same treatment.
Yes.
But also some significance would attach to the word settlement at the end of that. There are gaps with regard to the settlement of injured parties' claims. That's the...
It does mean presumably equivalent or roughly equivalent.
Indeed.
Yes.
Indeed, Lord. And then one notes just 13 and 16 in passing, this directive introduces the idea that all insurers must have a claims representative in every other EU member state to try to deal with that practical thing. When you come home from your holiday and you still feel your neck is bad from some accident which happened abroad, you don't have to start thinking, well, can I find a Greek lawyer? Can I find an Italian lawyer? You can actually just contact. It also provides for information bureaus. Contact the information bureau, find out the details of the insurer if you've got the registration of the vehicle, and also there will be a claims representative for every insurer around the EU in the UK.
Do they in fact pool and have a common or shared claims representative?
There are different models, Lord. Some do, some don't. Many do. Many share a claims representative. Somebody experienced, somebody like DECRA. DECRA is one of the names which occurs in some of the cases. But so whatever model you choose, I think in the MIB. Yes, I mean the MIB, in fact, is appointed by some as their claims representative for the UK, which is somebody very experienced in handling claims. But note 13 and 16, I just wanted to note those because the system of having a claims representative, it could be suggested, well, because the insurer's got a branch or agency equivalent to something to a branch or agency in the UK, in that case, then I can sue the insurer in the UK.
Not unless he was effectively carrying on his business, which normally would not be.
Well, indeed, my lord. But the argument would have been raised. And the recitals, absolutely, my lord. It would be rather sort of an ambitious argument. But absolutely. So 13, the system of having claims representatives in the injured parties member state of residence affect neither substantive law to be applied nor the matter of jurisdiction. 16, the activities of claims representatives is not sufficient in order to confer jurisdiction on the courts in the injured parties member state of residence if the rules of private international law on the conferral of jurisdiction do not so provide. So just having claims representatives doesn't say anything about substantive law or jurisdiction. And then the more specifically relevant recitals are 25, 29, 31. So 25. It's necessary to make provision for a compensation body to which the injured party may apply where the insurance undertaking has failed to appoint a representative or is manifestly dilatory in settling a claim. That's what one might refer to both of those scenarios as dilatory insurers, or where the insurance undertaking cannot be identified to guarantee that the injured party will not... or where the insurance undertaking cannot be identified, to guarantee that the injured party will not remain without the compensation to which it's entitled. We note that, and we'll come back to that in Article 1.1. The intervention of the compensation body should be limited to rare individual cases where the insurance undertaking has failed to comply with its duties in spite of the dissuasive effect of the potential imposition of penalties. So this is a recital which envisages both Article 6 and Article 7.
The last explanatory sentence doesn't actually really address the third category of situation.
No, Lord.
Anyway,
no.
there we are.
It's dealing with dilatory insurers.
Yeah.
Because obviously if you've got no insurer, if the vehicle's not identified,
Right.
absolutely.
Then we go on through the next recitals.
Yes. 29. Even though member states may provide that the claim, and this is, even though member states may provide the claim against the compensation body may be subsidiary, the injured person should not be obliged to present his claim to the person responsible for the accident. So you're not obliged to sue the tortfeasor before you present your claim to the compensation body. In this case, the injured party should be in at least the same position as in the case of a claim against the we perhaps insert there the relevant guarantee fund under Article 1.4 of Directive 84/5. So you wouldn't be required before, if the accident is in France, you wouldn't be required as a condition of approaching the Fonds de Garantie to sue the tortfeasor. And 31, it's very important.
Is 28 not also relevant?
That's on the right of reimbursement. Indeed.
Yeah, so you're going to come to that.
Because the right of reimbursement is applies. It's created in Article 6, and then there's an incorporation by reference into Article 7. Indeed, my Lord. The compensation body should have a right of subrogation as far as it's compensated the injured party, in order to facilitate enforcing the compensation body's claim against the insurance undertaking where it has failed to appoint a claims representative or is manifestly dilatory in settling a claim. The body providing compensation to the injured party's state should enjoy an automatic right of reimbursement with subrogation to the rights of the injured party on the part of the corresponding body in the state where the insurance undertaking is established. The latter body is best placed to institute proceedings for recourse against insurance undertaking. So that's dealing with the system for reimbursement really under Article 6 principally. But it
does assume that at every stage the same amount is going through.
Indeed, Lord. Indeed.
It's reimbursement, and then once you're reimbursed, the body which has reimbursed you is subrogated to the insured's rights.
Indeed.
The injured party's rights against the negligent driver.
Indeed, Lord.
Yeah.
And that reimbursement is provided for, in the sense that Your Lordship's quite, with respect, quite right, that it is supported.
There should be a comma after the word reimbursement. It's a rather bad translation, I think, or rather bad English.
Indeed. 31. Yes, well, indeed. And 30 relates to the same point. This system can be made to function by means of an agreement between the compensation bodies established or approved by the member states, defining their functions and obligations and the procedures for reimbursement. And that subsequently was the fourth directive agreement, which is subsequent to the directive, but prior to the regulations. So I wasn't going to deal with it.
And 31 is also relevant.
Well, absolutely, my Lord. And 31 is the most relevant. Yeah. Lordship is ahead of me. Where it is impossible to identify the insurer of the vehicle, provision should be made so that the ultimate debtor, we do stress that, in respect to the damages to be paid to the injured party, is the guarantee fund provided for in Article 1.4, situated in the member state where the non-insured vehicle, the use of which has caused the accident, is normally based. Where it's impossible to identify the vehicle, provision must be made so that the ultimate debtor is the guarantee fund provided for in Article 1.4 of Directive 84/5, situated in the member state in which the accident occurred. So there's no doubt that it isn't the compensation body which is to be the ultimate debtor. It is, in a sense, we say, we've used the term, I think, in our written case, claims handler. It is in that situation, it's in a similar situation, we say, to the claims representative who would investigate a claim, the claims representative of an insurer, who would investigate the claim, who would handle the claim, settle the claim, and then seek reimbursement from the insurer, and if not from the insurer in the home state. Now, Article 1.1, we say is fundamental to the way in which one must approach this directive. The objective of this directive is to lay down special provisions applicable to injured parties entitled to compensation in respect of any loss or injury resulting from accidents occurring in a member state other than the member state of residence of the injured party, which are caused by the use of vehicles insured and normally based in a member state. And then there's an extension in the second subparagraph for accidents in third countries involving EU vehicles. The critical part is the objective of this directive is to lay down special provisions applicable to injured parties entitled to compensation. The operation of this directive presupposes that you have a right to compensation against somebody before you're within the scope of this directive. And Article 1.1 is in general terms because there are various parties against whom one can have a right to compensation. One can have a right to compensation, an entitlement to compensation, using the words of Article 1.1, against an insurer. Well, it's obviously against the tortfeasor, against the insurer or against the guarantee fund in the place of the accident, the member state of the accident. Then the definitions. So insurance undertaking is that which has received its official authorization, and the vehicle is a reference. It's a vehicle as defined in the first directive. Injured party. That was the cross-reference I noted when I went to the first directive. Injured party means an injured party as defined in Article 1.2, which was the party who, it mirrors the wording of 1.1, any person entitled to compensation in respect of any loss or injury caused by vehicles. So Article 3, we've already looked at very briefly when I was opening. Each member state shall ensure that injured parties referred to in Article 1, in accents within the meaning of that provision, enjoy a direct right of action against the insurance undertaking, covering the responsible person against civil liability. So that gives you the direct right of action. And what I was focusing on in my opening remarks was the Article 18, the law applicable to that direct right of action, to determine whether or not you have that direct right of action. And we had a brief exchange about that earlier. But that is, of course, that direct right of action is dependent on you being an injured party. If you're only an injured party if you're entitled to compensation for the entitled to compensation in respect of any loss or injury caused by vehicles. So that's the first right. We note in passing Article 4 is the article which which makes sure that each member state should take all measures necessary to ensure that all the insurance undertakings covering the risks appoint a claims representative in each member state other than that in which they have received their official authorization. So they've all got to have a claims representative. And then 5 creates the information centres, or requires the creation of information centres I referred to. Establish or approve an information centre responsible for giving various information. So if you come back home, you've just got the registration plate of the vehicle, then you can still find out who the insurer is, who the defendant is, and so on and so forth. But, of course, 4 and 5 are concerned with the insured case. And then six, just while I'm on that point of the injured party, both 6 and 7 use the same term. Each member state shall establish or approve a compensation body responsible for providing compensation to injured parties. That's what requires member states to set up a compensation body. And then such injured parties may present a claim in the opening words of Article 6. And similarly, in Article 7, one notes in the second line, the injured party may apply for compensation. This injured party, it all goes back to that first directive. Any person entitled to compensation in respect of any loss or injury caused by vehicles. And it's that entitlement to compensation. We go back there to Lord Hoffman's words in paragraph 24 of Harding and Whelan's. There's no sense in talking about a person being liable. They must be liable for something. So it's critical in this case, we say, to focus on the nature of the victim's entitlement. We've already seen that the fact that you have a direct right of action against an insurer doesn't tell you anything about what you've got a direct right of action for, because that's already established. You already have your entitlement to compensation against the tortfeasor. And you can assert that right against the insurer. That's what the direct right of action is telling you. So, in 6, the ultimate debtor is the tortfeasor or his insurer. But just note at the outset, Articles 6 and 7 are giving the compensation body a role of a very different nature. In Article 6, the compensation body is, in a sense, an intermediary for the foreign insurer, the dilatory foreign insurer. Whereas in 7, the compensation body is an intermediary for the foreign guarantee fund. Just looking down 6, so after 6.1, the opening words, member states must create this body, establish or approve, and so in the UK context, it is the MIB who wears this hat as well, but in Spanish context it is not. So injured parties may present a claim to the compensation body in their member state of residence. Essentially, if there's been no reasoned reply, or there's been a failure, that's a reasoned reply to the claim, if the insurance undertaking has failed to appoint a claims representative. So if you're in the situation where there's no claims representative appointed, you can't go to anybody to deal on behalf of the insurer in your own country, then you can go to the compensation body. But note, after paragraphs A and B, injured parties, still on page 345, may not, however, present a claim to the compensation body if they have taken legal action directly against the insurance undertaking. There the insurance undertaking remains the defendant. Compensation body shall take action within 2 months of the date when the injured party presents a claim for compensation to it, but shall terminate its action if the insurance undertaking or its claims representative subsequently makes a reasoned reply to the claim. And that's interesting because the compensation body is faced with a dilatory foreign insurer, and the injured party therefore presents a claim to the compensation body, but the compensation body is instructed to terminate its action if the insurance undertaking or its claims representative subsequently makes a reasoned reply to the claim. So in the Greek accident context, the victim comes back to England and seeks to contact the Greek insurer or his claims representative. The claims representative doesn't respond, and so the compensation body gets involved. But then belatedly, the claims representative for the Greek insurer says, "Oh yes, sorry, I didn't. I'm running behind. Here's my answer to your claim." At that point, the compensation body, its function is over, because the persuasive element of Article 6 has cut in. Because otherwise, the insurer, the Greek insurer, would face a claim being negotiated, settled, compensated by the MIB, in the English case, with no input on the quantum of damages to be granted. And of course, we know from my introductory remarks that the law applicable in the insurance context would, of course, be Greek law. And that's the same law remains applicable to liability and compensation, even if the claim is brought against the insurer, the Greek insurer. That's subject, of course, to, that's Greek law, I say, in accordance with Article 4 of the Rome 2. And there are, as we'll see in due course, slight glosses to that situation in Articles 4.2 and 4.3, which we'll come on to in due course. But there is this, in a sense, the impact of that paragraph I've just read means that if my learned friend's case were right, just in this context, in the Article 6 context, although of course we're doing Article 7, then there would be English law damages for the compensation body, but then it terminates its action if the insurance undertaking pops up. Oh, we're back into Greek law there.
Yeah. Can you just help me more structurally? How does this interrelate with the provision in the first directive that member states' motor insurers bureau should guarantee the settlement of accidents occurring in their territory by vehicles normally based in the territory of another member state? Isn't this an overlapping scheme? under that scheme, each member Motor Insurers Bureau was picking up accidents caused by foreign vehicles. And under this scheme, a different body, the compensation body, is picking up liability in respect of accidents caused by foreign vehicles.
Indeed, Lord, overlapping is the correct term. These are overlapping because one sees lower down the way in which the reimbursement provisions in 6.2 are constructed. And in fact, I was just going to note the information provision at the middle of the page, before going 6.2, the compensation body shall immediately inform the people who are actually liable, it really is, because the compensation body informs the insurer, the compensation body in the member state of the insurance undertaking's establishment, and if known, the person who caused the accident. So, compensation body...
I've lost you. Where were you reading?
Sorry, I'm sorry, my Lord. At the middle of 345,
Yes.
just the compensation
Oh,
body
it's
shall
immediate
immediately
form, I see.
inform
Yes, A, yes,
those
B.
A, B and C,
Yes, I see.
the people who are actually liable.
Can you just help me on this? Suppose you've got, as in this case, English or UK resident injured in Greece. Under Article 6, or under the scheme, is it right that in the first place the injured person has a choice? They could go against the compensation body in the state of the accident, but they can, because this article provides for it, go against the compensation body in their own country, i.e. the MIB.
Well, they could go against, in the place of the accident, they could go against the guarantee fund.
Yes, quite. So they've got the option in the first instance.
Yes.
Now, if they decide to go against the MIB, the compensation body in their own jurisdiction, the MIB then has to inform the insurance undertaking of the vehicle that it's received the claim and will respond within 2 months. I just want to understand that at that point, if the guarantee fund in the state of the accident says, yes, we acknowledge this and this is our reasoned response, then the MIB ceases acting in this capacity?
Well, I slightly misled you on my last answer because you're positing an insured case.
Yes.
And so the...
we're looking at Article 6.
In the place of the accident,
Yes.
you would go against... Well, you could summon the foreign insurer, whether they're in the state of the accident or another state. You could summon them to the English courts, or you could sue the insurer in their home court.
But if you go against the compensation body in the UK, not having presented a claim in Greece, and if the compensation body in the UK promptly informs the Greek insurer, and if the Greek insurer responds, is the effect of these paragraphs read together that the MIB then ceases to take any action?
Absolutely not. That's the system.
That is, yeah.
It's persuasive to try to persuade the insurers to come up to deal with this problem of delay. Everyone knows about the complaints about delay by insurers in dealing with matters, but these are personal injury damages.
But somewhere else under the overall scheme, doesn't the Greek insurer then have to appoint a UK handler so that the...
Yes, indeed, Lord. That's Article 4.
Yeah, so that the UK resident is told, right...
You go against DECRA or whatever it is.
Yes.
The MIB has notified the Greek insurer, we, the MIB, are dropping out of it because the Greek insurer has acknowledged the claim and it has now appointed a representative. You deal with them.
Indeed, Lord.
Got it?
Yeah.
Apparently, if you use your rights to pursue the insurance undertaking, relying on the Brussels regulation, then you don't have a right to present a claim to the compensation body.
That's right, Lord.
I suppose the answer is you're suing them. You're in contact with them.
Well, indeed.
They are responding. Yes.
They are responding, and in your own country, yes.
Yeah. Right.
So then, my Lord Mance asked about the system of reimbursement, or was referring to that. So this is 6.2. The compensation body, which has compensated the injured party in his member state of residence, shall be entitled to claim reimbursement of the sum paid by way of compensation from the compensation body in the member state of the insurance undertaking's establishment, which issued the policy. And that's the overlapping element. That overlaps the green card guarantee. The latter body, that in the place of establishment of the insurance undertaking, shall then be subrogated to the injured party in his rights against the person who caused the accident or his insurance undertaking, insofar as the compensation body in the member state of residence of the injured party has provided compensation for the loss or injury suffered. Each member state is obliged to acknowledge the subrogation as provided for by any other member state. So it's designed to encourage compensation bodies in member states to deal swiftly with accidents, but first of all to notify the persons who are actually liable, then drop out of the picture if one of them pops up. If they don't pop up, then the compensation body would pay and claim reimbursement of the sum paid from the compensation body in the member state of the insurance undertaking's establishment, who then is in a much better position to bring a claim against the insurance undertaking or otherwise pursue the insurance undertaking to pay.
So is the amount of compensation focused on in any of these provisions?
Not in Article 6.
Or indeed how the compensation throughout the whole of this scheme, these schemes, is calculated in accordance with what law?
Well, Lord, on that, on my in the member state of the accident column on my diagram, the Handling Bureau under the Green Card Scheme, both for insured and uninsured vehicles, guarantees settlement in accordance with own national law of compulsory insurance. And then at the bottom, the Guarantee Fund, place of the accident, pays under own laws, liability may be restricted, limited by member state options. That's the 1.4. The last subparagraph, Article 1.4. But Article 6 says nothing about the basis of compensation, but Article 1.1 of the 4th directive makes clear that your right in Article 6 is on the basis of your existing entitlement against the tortfeasor stroke insurer. Tortfeasor stroke insurer.
Well, I think the Court of Appeal, in the Jacobs accepted that the assumption behind the directive was that the same measure of damages would apply across the board.
Indeed.
One can argue as to whether that's implicit or more or less expressed, but it doesn't matter. That's the case which I imagine you're advancing.
Indeed, Lord. Indeed. And really on the purpose and scheme, and I'll go to it in due course, the Court of Appeal in Jacobs correctly summarised the purpose and scheme. The difference comes when you move from there, how much of that you carry across into looking at the regulations. And I think it's paragraph 10 of your Lordship's judgment in Bloomsbury. It's the I should quote the words, but it's legal. It's the purpose and context. Yes, the statutory purpose and general scheme by which, in matters of statutory construction, the statutory purpose and general scheme by which we put into effect are of central importance. That's paragraph 16 of our case. I think it's paragraph 16. The number changed. Okay.
Well, if we're not careful, we'll be getting back to an argument about whether you look at the precise words or whether you...
Well, Lord, with
It's a more holistic exercise.
With respect, the error, we say, the fundamental error of the Court of Appeal was to give insufficient weight to the scheme. Because they look at the directives, form conclusions on the scheme, then look at the wording of the regulations and say, well, the wording's the natural meaning of the words.
You would say if they'd stuck to the directive, they wouldn't have made the mistake of construing the regulations in the way they did.
Where was this passage in Bloomsbury? Fish? It's at the tab 30 in bundle 3. What was the passage you were referring to?
I think it's paragraph 10.
Yeah.
Lord.
Yeah.
Well, the other point about the Court of Appeal judgment is they may have assumed, I think you suggest, that it was a one-way street. In other words, that there was no problem about reading the regulations in the way they did because it would always be beneficial. But
absolutely.
I mean, you pointed out at the outset that's by no means the case.
That's fundamental to our case, that had the UK provided for the regulations, you can get the better of English law or any foreign applicable foreign law, then that would be a very different position, because 10.4 of the directive permits you to gold plate. Member states may bring into force provisions which are more favourable to the injured party. What they can't do is deprive the Brit injured in Ireland of the Irish damages, which seem to be more generous, or the widow of a gentleman killed in an accident in Italy.
Yeah.
Deprive the people who are entitled, because and that was really paragraph 64 of Blois to the same effect. And one might say that Lord Justice Morbick in Jacobs did acknowledge that there may be more or less, but the approach effectively. For those who are getting less, it just lumbers them with that. It says, well, if you get less, you get less. That's English law. Well, if you get less, that's just too bad.
But you say that is impermissible because of the directive.
Well, indeed, Lord.
And if that's impermissible, then you have to read Regulation 13 differently from the Court of Appeal.
Indeed, my Lord, yes. Indeed. Because it's the effective protection of EU law rights, in a sense, what this is saying. If we are right on the scheme, and in accordance with really what the Court of Appeal found on the scheme, if we're right on the scheme, then you have to read the UK regulations in accordance with that. And you can't...
Well, only if it's possible.
Absolutely.
You can't read them contra legem, but I mean, we are entitled to do at the moment some quite radical things like ignoring words.
Well, indeed, my Lord. I mean, and obviously, if one weren't able to do that, then the person who has a serious accident in Ireland would sue the MIB in England for the uninsured accident in England, sue the MIB in England, get what it gets, get what the victim gets, and then sue the government, presumably under Frankovich, for saying, well, you didn't implement the scheme, and therefore entitled to get the top-up from the government. That's the sort of the overview. So against that, and I just noticed at the back, I'm sorry, my Lord, yes, sorry, Your Lordship, the scheme, of course, just Your Lordship will no doubt remember that in Bloomsbury, it was the interpretation of the word landed. And in that passage, you refer to charter reinsurance against Fagan, maybe more familiar to some of Your Lordships. In charter reinsurance, the words being interpreted by Lord Mustill were actually paid in a reinsurance context. And the question was whether there had to be some detriment, some money which had actually passed from the reinsurer to the insurer, or not. And
not actually paid.
Well, indeed, my Lord. It's interpreted as not actually paid. Well, indeed.
Well, Lord Hoffman gave some very attractive examples of domestic nature. The wife coming home and telling her husband she'd bought a dress. It's a slightly sexist example, if it in retrospect, but what did you pay for it? £100. Well, she hasn't paid a bean yet. It's all can come in on the bill in a month's
Those
time.
examples is that they assume a context in which people don't mind their language.
Well, but be that as it may, I mean, charter reinsurance, as Lord Hoffman did say there, that the natural words is not necessarily, natural meaning of the words, which was really where Lord Justice Morbick was in Jacobs, is not a very helpful starting point when you're dealing with a large scheme.
If I remember rightly, in Charter and Fagan, I think £15 billion was said to depend on the answer, so what actually paid meant, which is...
And of course, the first instance judge's decision was upheld in the House of Lords in that case. But and in the landed case was Lord Justice Stephen Richards. So this Bloomsbury case, Lord Justice Stephen Richards in the Court of Appeal asked himself what landed meant. And of course, he knows when he pulls a fish out of the Welsh rivers that it means bring it to the bank. And therefore landed must mean bringing fish to land for the first time. The trouble was that landed was used as the basis for imposing a levy on sea fish and sea fish products sold in the United Kingdom. And the people who had paid levy on imported sea fish said, well, these sea fish were not landed in the United Kingdom. They were landed in France, Spain, Iceland, and then we put them into ice, shipped them to China, put them into ice packets, brought them back to the UK, and there's no way can they be said to have been landed in the United Kingdom. Lord Justice Richard accepted that argument, and he accepted that various anomalies arose out of the scheme, and that this meaning of the word landed wouldn't fit very well with the scheme at issue under the Fisheries Act 1981.
Which was to fund the Sea Fish Industry Authority.
Absolutely.
Which wouldn't have had anything like the same income if landed had had the narrow meaning.
Well, I don't think it would have survived had landed had the narrow meaning, but there we are. But it's just to point out that that approach which one sees of let's look at the natural meaning of the words, and then let's see whether it's consistent with the scheme. What Bloomsbury is saying is that is not a legitimate approach where you are dealing with a complex scheme. You start with a scheme and then you apply that scheme in order to determine what the words should mean.
Because you should get the same result whichever way you start, wherever you start.
Well, indeed, Lord. And we do rely both on the words in this case and also, in effect, the context, because that's what the scheme is, it's the context. But there are cases like Charteree where...
Well, perhaps you better stick to cases in which you were counsel in this matter. I see.
It's the cases one knows, my lord. But I wasn't a counsel, obviously, in Charter Reinsurance. And then I come on to Article 7. This is Article 25 of the Codified Directive. I'm conscious, actually, I haven't been giving your lordships the cross-reference to the Codified Directive. There is a cross-reference table at the back of the Codified Directive, but it is Article 25, and it is truly codifying. So
I see. We'll find everything in the sixth directive, which came from the first to the fourth, or probably the first to the fifth. Do
yes.
we? It's all somewhere there. Yes. Right. Well, we haven't been. I suppose that when we come to write a judgment, we'll have to refer to the sixth directive.
Well, indeed, Lord. But I still feel I'm denied over this. But I felt that really it was the only way is to go through 1, 2, 4, and then to show your lordships.
So, which was the equivalent of Article 7 in the sixth directive?
Yes, Article 25, Lord.
25.
And the regulation itself
yes,
talks about it being there to implement the fourth directive.
Indeed.
So you
yes,
entitled to refer to the fourth directive because it's explicitly referred to in the regulation.
Right, where do we go?
So if it is impossible to identify the vehicle, so I'm back on page 346, I'm looking at the fourth directive, Article 7. It's impossible to identify the vehicle within 2 months following the accident. It's impossible to identify the insurance undertaking. And then we come back to those words, the injured party may apply. So that's the person from the first directive who has the entitlement to compensation against in respect of any loss or injury caused by vehicles. As we know, either against the tortfeasor or against tortfeasor insurer. Here there is no insurer, so your entitlement to compensation is limited to your right against the tortfeasor. So, and that's a may apply for compensation from the compensation body in the member state where he resides. Compensation shall be provided, and these are the critical words, in accordance with the provisions of Article 1 of Directive 84/5. The compensation body, and then we deal with reimbursement, shall then have a claim on the conditions laid down in Article 6.2 of this directive. And then there are three options, the two within the EU. Where the insurance undertaking cannot be identified, against the guarantee fund provided for in Article 1.4 in the member state where the vehicle is normally based. In the case of an unidentified vehicle, against the guarantee fund in the member state in which the accident took place. So, in a sense, those use the same term, have a claim, and on the conditions laid down in 6.2, it's the compensation body, so looking back at 6.2, which has compensated the injured party, whose member state of residence, shall be entitled to claim reimbursement of the sum paid by way of compensation. And then it's not from the compensation body of the member state insurance undertaking's establishment, but we then continue with the words of A, B, and if necessary, C. So, the first thing to note about those words in Article 7, the compensation shall be provided in accordance with the provisions of Article 1 of the second directive, is that it doesn't use the words, Article 7 does not use the words from Article 2.2 of the first directive on page 329, which were each national bureau, each handling bureau guarantees settlement in accordance with the provisions of its own national law on compulsory insurance. So the first thing to note about in accordance with the provisions of Article 1 is that it could have so easily said, if it was meaning that a victim comes home and gets the victim's domicile damages, could have said that. It doesn't. What we say is that, in accordance with, fixes the liability by reference to the position of a particular guarantee fund, and that that's what the purpose of, in accordance with the provisions of Article 1, is. It's important to note in this context, as I've already underlined in the second directive, that different guarantee funds provide differing terms of cover, in the sense that their liability may be more or less subsidiary, may not be subsidiary at all. Their liability may be subject to restrictions in the event of property damage, in the event of a passenger getting into a vehicle which it knows is uninsured. What the sentence cannot be doing is referring to any guarantee fund. And reading this provision, it is the scheme of the first and second directives which shows us, we say, that liability and compensation for uninsured vehicles is determined pursuant to the law of the place of the accident. That's my central column on my diagram. So uninsured vehicles under the green card scheme at the top, the handling bureau applies its own law, and at the bottom the guarantee fund is required to apply its own law.
Can you just say again, you say the words in accordance with the provisions of Article 1 of the second directive are referring to the provisions of Article 1 which are dealing with minimum requirements of what?
They're dealing with the setting up. Particularly the setting up of the guarantee fund. So what we say is that the compensation provided shall be that which it's compensation at least up to the limits of the insurance obligation for damage to property or personal injuries. Yes. It's 1, 2, and particularly 4.
Yes.
And so the compensation to be provided is that which the guarantee fund of the place of the accident would provide.
Yes, because the second directive is focused on the place of the accident.
That's what we say, Lord, yes.
Yes.
Well, you say that the subparagraphs A, B and C then identify the particular fund against which there can be, or to which there can be recourse. Little a takes you to the guarantee fund under 1.4 of the second directive, and that to give coherence to it, the indemnity sought over must sensibly be that which reflects the obligation of each of those guarantee funds, and that's a strong pointer to what is the liability of the victim home state fund, which it then passes over.
Yes, the victim home state fund, there's nothing to indicate that the directive is providing for the law of the home state, the victim's home state, to apply. Indeed, the contrary is the case, that the indication is that it's the law of the guarantee fund of the state of the accident.
Right.
The reimbursement provisions, the first one is in A, the vehicle where the member state where the vehicle is normally based.
Yeah.
If I can go back to my plan, I'll see if you've lost somewhere under that. There's my diagram. The guarantee fund in the centre column, the member state of the accident, would pay according to its own law. If the vehicle is from another member state, then that case is dealt with between the paying bureau and the handling bureau under the green card scheme. So the logic of 7A is that, well, the ultimate liability should sit with the member state where the vehicle is normally kept, because it was their responsibility under Article 3 to ensure that all vehicles were insured.
Yeah, and if I understand it right, you're saying that if the claimant had gone as he or she might directly against the relevant guarantee fund identified in A, B, or C, the liability of that fund to the claimant would have been to pay that for which there would have been liability under the law of the tort, and that you would not expect a provision which is procedurally providing a convenience for the claimant to alter the nature of the right.
Absolutely, Lord.
Yeah.
That's it. The only rider of that, Lord, is that against whom could he have gone? Because the natural place when you involved in an accident in a particular country is that you would go to the guarantee fund of that state, because that state is required to set up a guarantee fund.
Yeah.
And so
Well, I suppose many people think it'd be best to go to the guarantee fund of their home state.
but they're not required.
They're easy to deal with.
But those guarantee funds are not required to be liable for accidents abroad, Lord.
Well, presumably the whole point of the scheme is to meet my Lord's point, namely to give you a convenient
Indeed.
interlocutor, but the
yes.
question what they pay is a different thing.
Is there any issue that the claimant could have gone under Article in this context against the relevant one of the three guarantee funds in A, B, and C?
It could, of course, the A and B are in the same place in this case. It's a
Yes,
Greek
right.
vehicle in Greece, and so there's no doubt. I mean, it's common ground.
But as a matter of structure, that happens to be the case here, but we're
Yes.
looking at an international document. As a matter of structure, right in understanding there's no dispute that the claimant under the scheme would have the ability to go directly at the fund in A, B, or C.
Lord, if it had been, perhaps back to in opening, I posited a French vehicle driving in Greece. So for the French vehicle driving in Greece, the claimant could have approached the Greek bureau, which would then handle the claim, and would then seek reimbursement from the French bureau. But there's no requirement under the directives that the French guarantee fund be susceptible to direct claims from claimants injured in Greece from other EU member states.
Sorry, say that again. Say that again.
So there's no requirement in my diagram, the left-hand column, that the guarantee fund, there's no requirement that an English claimant injured in Greece by, say, a French vehicle, there's no requirement that the Greek guarantee fund that the French guarantee fund accept direct claims by victims against the French guarantee fund.
Oh, right. So if it's a French vehicle injures an English person in Greece, although under 7A, it's the French fund which ultimately responds because although the insurers haven't been identified, it's known that the vehicle is normally based in France. Under the scheme, the claimant, you say, could not go directly to the French compensating authority and say, here's my claim against you.
Lord, no. The way in which it would happen would be you would go to the Greek Bureau. Well, the Greek Bureau, which then is reimbursed by the French Bureau, and then, as I understand it, there may well be provision for reimbursement between the paying bureau in France, on the left-hand side of my diagram, and the guarantee fund in France.
Okay, so but
That's a matter of internal law.
Simplifies it because you're saying that in each case, if the accident's in Greece, no matter where the vehicle came from, the claimant could have gone to the Greek compensation body.
But if it's a foreign traffic vehicle, you have to go to the handling. Well, I think it's the no matter where the vehicle comes from. I think it's perhaps certainly if it's an accident in Greece with a Greek vehicle, you go to the Greek guarantee fund.
Yeah.
When it's a visiting vehicle, that's a green card case. So, and it may be, I'm not sure in Greece whether the handling bureau and the guarantee fund are the same body. Whether the Greek bureau is the same body as the guarantee fund. But if it's a visiting vehicle, then that is still handled by the green card scheme.
Yeah.
That is still a bureau liability or responsibility under the first directive to handle and settle that and then seek reimbursement from France.
Would it be possible to reduce that, just a very short note of a few lines?
So, indeed, my Lord, Junior, just draws attention to the point I've already made, I think, that both the handling bureau and the guarantee fund, of course, act according to their own laws.
Yeah.
It's a centering of the compensation in relation to the accident on the member state of the accident by the directives.
Yeah. Thank you.
There is some short reference to the TRAVO, to the fourth directive. It's in Bundle 1, Tab 12. We get the European Parliament proposed some amendments to the draft directive. The draft directive is in the previous tab. It's MS 521. That's what I was going to look at, but the Parliament report, it starts at 502. And the Commission proposal is back on the previous tab. But I think I can take it from the parliamentary proposal and the reaction to it by the Commission. So, the draft Article 7, it was at that time Article 6.
What page do you find that?
So on page 521, my Lord, I'm sorry. So we have, in the left-hand column, we have the Commission proposal, as it was, and on the right-hand column, we have the European Parliament proposal, counter-proposal. And so Article 6, which is Head Amendment 34, this is essentially the then draft of Article 7. And what the Parliament proposed was that the entire article should be deleted, not in order to remove that right, but in order to fuse that right with the right in Article 6. And we see that from 509. I don't know, 50, where the Parliament, in fact it's 510, one sees that the Parliament's proposed deleting recital 13, which dealt with the Article 7 body, and really incorporating it into recital 12, which was the Article 6 became the Article 6 body, compensation body. And so whereas necessary to make provision for a compensation body to which the victim may apply where the insurer cannot be identified, has failed to appoint a claims representative or is manifestly demonstratory. So what the Parliament will say, we don't need Article 7 separately, let's just put it together, all in one big article. And what is of interest, my lords, is to see the way in which the Commission reacted to that, and why Article 7 remains separate. That's in the next tab, at page 534. I just note in relation to recitals, particularly in relation to recital 13, which became 31 in the final directive. So the Commission notes these recitals have been modified. Firstly, I'll take into
Where are you reading from?
I'm sorry, at the bottom of page 534, my lord. 534 on the left-hand page. So those recitals have been modified. Firstly, in order to take into consideration part of the suggestions of Parliament Amendment number 13, which we just looked at. Recital 13 announces that the cases where the insurer cannot be identified can also be settled by the compensation body in the injured party's member state of residence, in order to make it easier for the visiting victim by establishing only one contact point. So I pause there. That's the reason why you're using the same body. You're using a compensation compensation body under Article 6 and Article 7. The reason it's accepted under Article 7 is just to make it easier for a claimant who can say, right, I just approach the compensation body if it's an accident abroad. There's only one contact point. However, this new arrangement has been supplemented by a clear reference in Recital 13 that the existing system of insurance directives has to be respected. That's what became Article 31, or Recital 31. Uninsured or unidentified vehicles are treated under the second directive and fall within the competence of the guarantee funds. Essentially, it's quite a willingness to create a right against the compensation body, but not to change where the ultimate responsibility for that lies. Because that is the system of the insurance directives. And then, in order to ensure coherence, just at the bottom of that page, the last sentence, the same page, to ensure coherence with the directive, Recital 13 clearly states final responsibility lies with the guarantee funds according to Article 1.4 of Directive 84.5. So then there's commentary on what became Article 7 at page 540. And there are two paragraphs which are actually quoted in our written case. But in any event, I'll go to them because in context, sometimes it helps see them in context. Article 6, so it became Article 7, about a third of the way down page 540. Regarding cases where the insurer cannot be identified, the Commission has followed Parliament's suggestion provided for in Amendment 33 to give the injured party the possibility to use the mechanism of the compensation bodies, provided that the existing system of insurance directives is respected. So what it's saying is you can borrow this compensation body, which we're creating in any event for Article 6, you can borrow that to use for Article 7, but provided that the existing system of insurance directives is respected. So uninsured unidentified vehicles treated under the second directive fall within the competence of the guarantee funds. Certainly, in order to make it easier for the visiting victim, establish only one contact point, the intervention of the compensation body has been accepted, the final responsibility lies with the guarantee funds according to 1.4. But contrary to the suggestion in Amendment 34, the concrete reference to the mechanism provided for in Article 1.4 is maintained. That was the deletion of the whole article in the text to make clear that in case of unidentified or uninsured vehicles, the responsibility for compensating the injured party lies with the guarantee fund and not with the compensation body established by the present directive. Nevertheless, the idea included in Amendment 33, i.e. to give the injured party the possibility to present a claim even in cases where the insurer cannot be identified, is acceptable, provided that afterwards the mechanism of compensation bodies does not intervene anymore, but the final responsibility for reimbursing the compensation body in the member state of the insured party's residence are the responsible guarantee funds of the member state of the accident or the member state of registration of the responsible vehicle. So that we say it's quite plain from these Travo that the compensation body is not intended to bear any ultimate liability. It is, in truth, a claims handler for these cases. So that the existing system of the directives remains untouched, with the Guarantee Fund and Handling Bureau of the State of the Accident applying their own law and being reimbursed if it's a visiting vehicle. And when the victim for ease is given a local body to sue, that doesn't change the nature or scope of the cause of action. Like the direct action case, you're given a right to sue somebody else who looks, to all intents and purposes, like an insurer. You're given a right to sue them, but that doesn't change the nature of the right. Before leaving the fourth directive, I should just deal with one paragraph in Lord Justice Moore-Bick's judgment, where he deals with the words "in accordance with," and we say doesn't get enough out of them. This is paragraph 32 in it's bundle 3, tab 38, page 1161.
Page.
Bundle 3, tab 38. Page 1161. And you may just want to read that paragraph 32, because it's there that he's dealing with in accordance with.
So where is he getting those words from?
From Article 1, from Article 7.
Yes.
Yes, I see. Although he's dealing with the regulations, he's getting...
Indeed, he comes back
Yeah.
at this stage.
Yeah.
So,
You agree with this part of the judgment?
well, my Lord, yes, we adopt part of it, but we say he didn't go far enough. So what he says is that there must be liability, at least I hope I'm correctly stating it, but there must be liability on the part of the driver, because the object is to put the uninsured victim on a par with the insured victim. Because insured victims have to establish liability against the driver. Similarly, uninsured victims have to establish liability against the driver in order to sue the compensation body. But the way in which we say he doesn't go far enough, there's no rationale given for limiting this reasoning to the issue of liability. The words do not say provided that the driver is liable. And so we submit that the words in accordance with.
What puzzles me is he's not actually quoting Article 7, because he said that his quote reads, shall compensate the injured party, whereas Article 7 reads, the compensation shall be provided in accordance with. Is he quoting something else?
I think he's coming from Regulation 13. I think.
So he is quoting, so it is regulation.
So I'm sorry, Lord.
Yes.
But he's picking up the words, yes. Indeed. So because he's in he's in Regulation 13, but in a sense, he's attributing, I'm sorry, my lord,
Yes,
you're
right,
quite right. He's attributing a meaning to Regulation 13,
Yes.
which he seems to be drawing on the terms of the directive in order to attribute that meaning. And we say that, I mean, our case is based squarely on the directives, and so...
You say he doesn't really grapple with your point on the directive at all?
No.
Or your main point on the directive?
Indeed, my lord. Because we submit...
That's the whole case, really, isn't it?
I won't sit down just yet, my lord.
Well, that's it, isn't it? I mean, that is the whole point of this part of the case.
It
We should hear
is.
some more, I think.
Well, I think there's
Well,
something
maybe hear some more, but that's the point.
That's the point, my lord.
It's either a good point or a bad point.
Well, absolutely. And we submit that the liability of the guarantee fund of the place of the accident, including the compensation payable, is being incorporated by these words in accordance with. Lord Justice Morbick comes part of the way with us because he's prepared to accept that you need liability of the driver in order to establish a claim against the guarantee fund. So he sees that you've got no claim against the Greek guarantee fund unless the driver's liable, he says. And that's right. But in a sense, he's coming part, that's why I say to my Lord Toulson, he's coming part of the way towards our case. But he doesn't draw what we say is the necessary conclusion, which is that it is incorporating not only the liability of, not only do you need the liability of the driver to plead to have a case against the guarantee fund, you've got your right against the guarantee fund is a right for something.
Well, it comes back to the question: what is the person insured entitled to?
Indeed, Lord. That's why we
The
stress
basic
Article 1.
entitlement, which all this is parasitic on, is the entitlement against the tortfeasor. It's giving a remedy against all sorts of people in respect to that. That's your case.
Absolutely, Lord. That's it. And so then the regulations. Before going to the regulations, I do go briefly to the fourth directive agreement. It's at MS 655. It's in bundle 2. But why am I going to it first? It is subsequent to the directive, but prior to the regulations. The fourth directive agreement is a condition precedent to the operation of Articles 6 and 7. When I'm speaking, it's in tab 20 of bundle 2. The way we put it is to say that it's an important part of the factual context against which the draftsman of the English regulations must be presumed to have worked. We say that the court, in interpreting the regulations, must place itself in the position of the draftsman and assume the knowledge of the matrix of facts available to him. And I take that, the matrix of facts point, from Lord Simon in Black Clawson. It's in the bundle at MS 890, where a public report to Parliament was considered an important part of the factual matrix. What we say is that the draftsman writing the 2003 regulations would have had available to him the directive, would have had available to him in the directive, he would have seen Articles 6 and 7 don't operate until there's this agreement. He would necessarily have had available to him the fourth directive agreement. But to be clear, this point was raised in Bloy by Mr. Randolph in Bloy, but he relied upon the agreement to interpret both the directive and the regulations. I mean, my respectful submission would be it would be difficult to rely upon something subsequent to the directive to interpret the directive, even though it is a condition precedent. But on the regulations, we do say it is part of a factual context. So in the fourth directive agreement, so this is the agreement between compensation bodies and guarantee funds, starts at page 655. It's dated 29th of April 2002. So it's tab 20 of bundle 2. And the first recital refers to the fourth directive. And in the definitions, for the purposes of this agreement, it adopts the definitions taken from the various directives. I don't need to go to those. The first part deals with Article 6 cases, reimbursement between guarantee funds and Article 6 cases. The second part starts on page 659. That deals with reimbursement in Article 7 cases. And that's what we're concerned with. The aim of the second part of this agreement is to define the tasks and obligations of the undersigned compensation bodies and guarantee funds within the framework of Article 7 of the 4th Directive, as well as the reimbursement procedures. And so Clause 6 recites the fact that it's the compensation body is to compensate injured parties following an accident, where one of two situations, where the identification of the vehicle is not possible, it's impossible to identify the insurance undertaking. And then 7.1, in either of the situations referred to in Clause 6, the compensation body which has received a claim must immediately inform, depending on the circumstances, either the guarantee fund defined in Article 1 of 84.5 of the member state in which the accident took place, or the guarantee fund of the member state in which the road traffic vehicle which caused the accident is normally based. When it makes a compensation payment to an injured party, the compensation body shall reply to requests for information enabling the claim to be assessed, apply in evaluating liability and assessing compensation the law of the country in which the accident occurred. And the third indent on 7.2, the compensation body shall comply with the provisions of Article 1 of 84.5. Which effectively imports the restrictions, such as they may be. There may be no restrictions, but maybe a subsidiary liability. It may be there's some limitation on recovery of damages for damage to property. Or it may incorporate that exception for persons who got into a vehicle knowing that it was uninsured. And then the guarantee fund in 7.3, the member state in which the accident took place, even though it is not responsible for the reimbursement described in section 3 below, shall provide, upon request, the compensation body to which a claim for compensation has been made, all necessary advice, assistance, and information, in particular on the content of the applicable law, and all documents it has available relating to the accident which this body wishes to obtain. And then the reimbursement procedures in 8.1 and 8.2. When a compensation body is compensated upon request of an injured party, it's entitled to receive, depending on the circumstances of the accident, either from the guarantee fund of the member state in the accident in which the accident took place, or the guarantee fund of the member state in which the road traffic vehicle which caused the accident is normally based, reimbursement containing the exclusion of everything else, the following: the amount paid in compensation, sums for external services, handling fees. 8.2. The amount to be reimbursed may only be disputed by the final paying guarantee fund if the compensation body which settled the injured party's claim has ignored objective material information given to it or has not observed the rules of applicable law. So in the regulations, there's in bundle 2, it's tab 19. I should just say, before I actually start with the regulations themselves, just mention the principles. I think that some of these I've already mentioned. I mean, we say, first of all, that the regulations were designed to implement the directive. We quote at paragraph 61 of our written case what the explanatory memorandum says. Makes it clear. They were to implement Articles 4, 5 and 6. There's no suggestion in the transposition note, which is in the supplemental bundle at 63, 65.
Supplemental 360.
I'm sorry, Ronald?
Supplemental what?
Supplemental bundle, so supplemental
Bundle.
63, 65 to 65.
Okay, thank you. No suggestion.
No suggestion in the transposition note. The government is seeking to do anything else additional to implementing.
No suggestion of gold plating.
Indeed, my Lord. That's it. So we will be relying on the general principles stated in the written case at 17, that the 2003 regulations should be construed consistently with and to reflect the directive, as far as possible, as my Lord Mance observed, the Mar-leasing principle. But we go further than that. In paragraph 18 of our written case, we cite the risk management case in the Supreme Court. And we say that unless there's an indication to do more than give effect to the directive, you must construe English legislation so as to give effect to the directive. So you are looking for something positive. I think we should go just briefly to risk management. It involved the transfer of undertakings regulations. Now that's bundle 4, tab 41. I'm sorry, not transfer of undertakings involved, sorry, the public contracts. Public procurement was the context. So starting on page 1220, the head note, essentially this was an award of a contract for insurance services by local authorities, and they awarded this contract to a form of local authority mutual insurer. My Lord Justice Sumption, Lord Sumption is, I think, if I recall correctly, well acquainted with the case. The award to a mutual, local authority mutual insurer was criticised on the basis that the procurement rules had not been followed. Public procurement rules had not been followed. The response to that was, well, there is this case called TECAL, which means that if the relevant conditions are fulfilled, we don't have to go through the hoops of the procurement regime, EU procurement regime. And we see that in the held on page 1220, allowing the appeal that the conditions set out in the TECAL exemption applied by implication to the public contracts regulations, the underlying purpose of which was to give effect to the Council Directive 2004. The exemption could apply to contracts of insurance, and then the conditions for the exemption to apply are that the public authority had to exercise control over this mutual insurer, and secondly, the body had to remain within the public authority sphere and not compete with other suppliers on the open market. Those are two critical conditions for the TECAL exemption to apply. And then it was argued that, in fact, what the UK was doing was, in a sense, gold-plating the Council directive by not incorporating the TECAL exemption and therefore applying the public procurement regime to all bodies, whether or not they have links with local authorities or not. That was the submission. And the gold-plating submission is in Lord Hope's judgment at page 1232, paragraph 21. And so the submission, the first sentence of 21 at C was that, well, construe these regulations in normal way for English regulations. Second sentence, they were within the powers of section 2.2 as it permits a domestic measure to be given to be wider in its effects than the EU measure to which it gives effect. It would not have been incompatible for them to have subjected more contracts to the procurement regime than EU law required. And then I think we can pick it up.
Maybe a slightly debatable proposition made. How far? Anyway, it doesn't matter.
Indeed, my lord. Yes, how far? The various points.
Section 2.2, something we looked at in USA and Nolan.
Indeed, my lord. And it is somewhat debatable, the various point, the Court of Appeal approach in Oakley. But
yes, anyway.
be that as it may. In 22, Lord Hope, I do not find these arguments persuasive. It's sufficient answer, as Mr. Sumption for Harrow submitted, to say that the basis for implying the TECAL exemption to the 2006 regulations is to be found in their underlying purpose, which was to give effect to the directive. They refer to the fact that TECAL was a considered policy of EU law. They note that TECAL in 23, TECAL applies equally to where the directive doesn't apply. It's a broad principle, it's a fundamental principle in 23. 24, it's true that section 2.2 is in wide terms, does not define any measures made under it doing the minimum necessary to give effect to the directive. But if it is to be within the powers of subsection, the measure has to arise out of or be related to an EU regulation, to an EU obligation. And that's the virus point, really, in 24.
Is there a virus point in this case? I mean, if Section 2.2 was used, of the European Communities Act, was used to make the motor vehicles regulations, on a possible view, Section 2.2 is not entitled, was not designed to enable you to give effect to a different scheme to the one which the directive required. Anyway, you haven't raised a varies point, but I mean there is a possible varies point here.
Yes, I mean, we've thought about that and discussed it. We thought that, I mean, it may be of more relevance in relation to Article 6, and which Article 6 and Regulation 12, which your lordships don't, we
Have to
say,
deal.
need to make a final decision.
Yes.
We felt
Because
that
because one can construe
Indeed.
Regulation 13
Indeed.
or
Yes.
is more.
whereas Regulation 12 does have those express words, apply the law of the party, United Kingdom.
Right. No, fine.
England and Wales. So, in 25, just at the bottom, just finishing off in risk management, so the meaning and effect of the 2006 regulations. I think it would be wrong to apply a literal approach to the words and phrases used. A purposeful approach should be adopted. Cameron's Ballroom nor Diplock indicated that regard must be had to the context in which the regulations were made, their subject matter and their purpose. And so he holds that in 26, that the technical exemption does apply to 2006 regulations, and therefore the relevant body, one didn't need to go through the procurement regime. And well, also, the next principle, which I want to draw your lordship's attention to before going to the detail of the regulations, is that member states are obliged to provide effective protection for EU law rights. Not, I think, a wholly uncontentious proposition. And if it's right, if I'm right so far, that the directive grants a right against the compensation body, which is coextensive with the right against the guarantee fund of the place of the accident, that right is one which must be protected. I can give your lordships a cross-reference. I mean, maybe we should go to in Evans, one of the only cases, it came before the Court of Justice on the, I've referred to it already, well, I haven't been to it. It came before the Court of Justice on the meaning and effect of the second directive, and there were issues about whether the rights against the guarantee fund had to include interest and costs. And I just draw your attention to a couple of paragraphs in that. It's bundle 4, tab 49. It's 1443. I'm going to go to first. Sorry, yes, 1443, paragraph 27 is the passage I've already referred your lordships to. That's where the overall objective, put unidentified uninsured vehicle, of the victims of unidentified uninsured, in a situation where the protection is equivalent to and as effective as that available to those injured by insured vehicles. And then 1461, which is what I was going to do next. It's really just in the dispositif, in the judgment, perhaps above all, the second paragraph on page 1461, the compensation awarded for damage or injury caused by an unidentified or insufficiently insured vehicle paid by the body authorised for that purpose is not required to include reimbursement of costs incurred by victims in connection with the processing of their application for compensation, except to the extent to which such reimbursement is necessary to safeguard the rights derived by victims from the second directive, in conformity with the principles of equivalence and effectiveness. And I do rely on the fact that the approach of the court is that the second directive is granting a right to the victim who can approach the guarantee fund.
What does it mean? How do you determine whether you're required to reimburse costs? How do you determine whether such reimbursement is necessary to safeguard the rights derived by victims from Directive 84.5 in conformity with the principles of equivalence and effectiveness?
In practice, if you've reasonably needed to incur costs in order to pursue your claim.
I see. The answer is if costs are necessary, then they can be recovered.
And that's a matter for appreciation of the National Court.
I see.
Yeah.
And the paragraph above that was concerned with interest. So the court doesn't find that you have to grant interest, but it does find that the amount awarded must take account of the effluxion of time until actual payment of the sums awarded in order to guarantee adequate compensation for the victims.
Yes.
So it's not specifying, there may be all sorts of different systems, maybe only on an annual basis, there may be compound interest, there may be all sorts of different systems. Or it may simply be a sum for each year beyond the accident.
Just award damages at the current rate, which
Well, indeed. Might be another way of doing it.
right.
So we do say that what is not legitimate in terms of protection of EU law rights is for Lord Justice Moore-Bick in Jacobs to envisage the possibility that a claimant may receive less under English damages, but still to adopt an approach which requires English law to be applied in all cases. An interpretation of Regulation 13, which applies English damages in all cases. Because the result of applying English damages in all cases is that there will be cases where you'll get less. And I've said already, of course, member state could, I think, but I haven't here, provide that, well, the better of English damages and foreign damages. But that's not what's been provided for here. So with that slightly lengthy introduction, I go to Regulation 13. In Bundle 2, tab 20, at page 649. Or perhaps I should go back to 643, because we haven't been to these regulations before. Sorry, it's under tab 19. So, these are the 2003 regulations, citation, and then the various definitions. Refer back in part to the directives. Provides for, in 3, for the information centres, for the specified information, for the maintenance supply of information by insurers and policyholders, by others, and then supply of information in 9 from the information centre. And then Regulation 10, MIB, is approved as the compensation body in the United Kingdom for the purposes of the 4th Motor Insurance Directive. Now, what that does, it doesn't do quite the same as 6.1 of the directive, because the 6.1 of the directive said you make national compensation body, authorise a national compensation body, making them responsible. This is simply setting up the body, or in a sense approving MIB to perform that function. I'll come back to 11 and 12, so we're focused on 13. So this regulation applies where an accident is caused by or arising out of the use of a vehicle which is normally based in an EEA state occurs on the territory of an EEA state other than the United Kingdom. So it's accidents outside the UK. And the injured party resides in the United Kingdom. That injured party has made a request for information under Regulation 9.2. It's proved impossible to identify the vehicle, use of which they should have been responsible, or so it's either untraced in C1 or C2 within a period of 2 months after the date of the request to identify an insurance undertaking which insures the use of the vehicle. So Roman 1 is untraced, Roman 2 is uninsured. And then where this regulation applies, the injured party may make a claim for compensation from the compensation body. So we know you can make a claim. The compensation body so far is not liable for that. So 2b, the compensation body shall compensate the injured party, and then the words, they're similar, they're almost identical to the directive, in accordance with the provisions of Article 1 of the Second Motor Insurance Directive. And we say our case is on the directives. That's a reference to, by way of compensation, the compensation body shall award that for which the guarantee fund of the state of the accident would be liable. Or is liable. Is liable because the Greek guarantee fund has a liability in respect of this case. And the claimant could have instituted proceedings in Greece. Of course, the fourth directive avoids the need for that, but she has the right against the Greek Guarantee Fund. And then the words which follow, as if it were the body authorised under paragraph 4 of that article, and the accident had occurred in Great Britain. So just taking the last words.
Sorry, where were you reading then?
I'm sorry, at the end of 13.2b.
Yes, thank you.
So there are two as-ifs there. The body authorised under paragraph 4 of the second directive, of Article 1 of the second directive, and the accident had occurred in Great Britain. So effectively it's as if the accident had occurred in Great Britain. If the accident had occurred in Great Britain, then the UK Guarantee Fund would have had liability. And so the draftsman says, well, let's take the fiction then that the accident occurs in Great Britain, because that is that for which the UK Guarantee Fund is liable. But the other words are necessary because the UK compensation body is not the UK Guarantee Fund, in the sense that the MIB wears separate hats. So, qua compensation body, you need to make it liable as if it were the UK Guarantee Fund. So effectively you've got two fictions. Pretend the accident happened in England and pretend that the compensation body is the Guarantee Fund. That is the UK Guarantee Fund. And by this rather convoluted route, the draftsman imposes on MIB, qua compensation body, the obligation required by Article 6.1 of the directive. It makes the compensation body responsible.
Is there some relevance here to the words Great Britain rather than the UK, which appears elsewhere?
Lord, that's simply dealing with the matter of Northern Ireland.
Yes, quite. But
It is.
Does that lead on to something?
Lord, I don't think that on our side of the court, it was explained to me, I'm sorry, it is to do with Northern Ireland, isn't it? Yes. Yes, the untraced drivers agreement is limited to Great Britain. And there's a separate one for Northern Ireland.
Right.
And
So it limits. Does it have a limiting factor for that reason?
well, there will be equivalent regulations for Northern Ireland law.
Yes, right.
Yes. I mean, there must be, because this is limiting it to Great Britain.
Yeah.
I haven't seen them, Lord, I'm sorry. We can, I'm sure, check that point over the luncheon adjournment, if that would be helpful.
And well, just a matter of curiosity, is there a different body in Northern Ireland?
No, it's the same MIB, it's a different. It's the same, separate.
It's the same body but separate agreement, my Lord.
Right, okay. It sounds as though it's nothing.
And in fact, my learned junior points out that the injured party resides in the United Kingdom. So I'm sorry, I should just take careful instructions on this sort of point.
Yeah, so it's a non-point.
We believe so, my Lord.
Yep.
But then Lord Justice Morbick in Jacobs really came with us on what I've said so far, but then said, well, the words are not spent, and I can still use the accent that occurred in Great Britain as indicating that English, I'm paraphrasing, it's unwise, I will go to it, as indicating that English law must apply to calculation of compensation. So if there's time, just, I don't know whether...
Your point is essentially compensation means compensation as it does, as we discussed earlier, in the directive. And the mere fact that if it were ordinary claim for damages, you could recover more at common law, is neither here nor there.
Absolutely, Lord. Yeah. So...
That is it, really, is it?
as counsel, my lord, your other lordships may remember that when the judge says that's it, you're reluctant to sit down.
And he's only one. Right. I think you were suggesting that you might have come to a convenient.
Well, that is convenient, my lord. Yes.
But entirely up to you. You've probably got another 2 minutes if you wanted to.
Well, maybe just to go quickly to Jacobs then, in 33, 34 of Jacobs, in bundle 3. So it's at tab 38. It's so 33 to 34 really accept, I think, broadly what I've been explaining to your lordships. I'm sure in much more erudite words. But in paragraph 35, essentially this is where he says that the words are not spent. The mechanism by which the Bureau's obligation to compensate persons in accidents occurring abroad involving insured or unidentified drivers is established is to treat the accidents having occurred in Great Britain. But in the absence of any provision limiting its scope, it is difficult to see why it should not also affect the principles governing the assessment of damages, particularly in the absence, at the time, of complete harmonisation of conflicts rules. And
That's where you say he went wrong, because he didn't look at the background.
indeed, my Lord.
Or
We
the-
say
or
that
the
just the
general
natural meaning,
scheme.
yes, the natural meaning of the words is not enough in that context. Just because words are capable of having a meaning doesn't inform us as to what their actual meaning is. On that note, my Lord.
Right, so shall we resume at 2 o'clock and look forward? You've got another half hour, haven't you?